A and then Amos dash JONES.
All right. And ma'am, we did have just a brief discussion off the record. Brother is in the military. He is D'Angelo Amos, and you are an occupant who lives in the residence. Is that correct?
Yes, ma'am.
All right. So good afternoon to you, ma'am. This is your first pretrial for non-payment of rent. You do have the right to hire and consult with your own attorney. You have the right to a jury trial if you assert that today or within writing within 5 days if given a second hearing, and you pay the associated costs. You also might be eligible for something called a conditional dismissal instead of a judgment if that's something you can work out with your landlord and the landlord's attorney. Mr. Morton, would you give me the balances you have it currently?
You're at this time, we have rents retained of $7,990.95, core cost of $178.43, for a total of $8,169.38.
All right. And Ms. Amos, you say that your brother is currently on active duty in the military, and Mr. Morton, you have confirmed that, correct?
That is correct, Your Honor. We have confirmed it.
Okay. And Ms. Amos, what was your plan? Well, first of all, have you applied for any rental assistance?
I myself have. I personally recently had a stroke, and I had let the apartments know that it was following a car accident by one of the residents here.
Hold on, Ms. Amos. Ms. Amos, I'm very sorry to hear that, but the timing of your case is very important. I need you to answer the questions that will start. Okay, that's okay. All right. Have you applied for rental assistance, or are you going to?
Yes, ma'am.
All right. So have you actually already applied?
I have to some of the places they've given me.
Can you tell me, well, the rest? Can you tell me where you've applied to?
Department of Human Services, St. Vincent de Paul, and the Community Housing Network, I believe it's called.
Okay. All right. So here's the deal. So if you send, not if, you must send in to me within the next 5 days, proof that you have applied for rental assistance. So with whoever you've been working with at CHN, make sure that you submit to me. I'm going to give you my email. Are you ready to take it?
Give me 1 second, please. Okay.
The email is civil@45dc.org. So C is in cat, I is in igloo, V is in vase, I is in igloo, L is in log, at 45, D is in district, C is in court.org. Do you want to read that back to me?
It is civil. It is civil@45dc.org.
Yes. All right. And they probably gave you a form to fill out to submit to the court. I'll take that. Or if you want to screenshot the proof that you've applied, I'll accept that also. Just send that in. We have to get it within the next 5 days. What that does is it triggers a 28-day period until the plaintiff can seek a judgment against you. But if I don't get it, they'll be able to come back and get the judgment. Do you understand that?
Oh, no. When you said they'll be able to come back and get the judgment, what does that mean?
You must submit proof to the court within the next 5 days to trigger that waiting period, to get that time to work with the rental assistance places.
Okay.
So I've got to have that proof that you've applied within the next 5 days.
Okay. Let me write that down in the next 5 days. Then let me look in my email while you proceed to see if they sent me an email copy or if I can log into DHS.
Okay, so Ms. Amos, I've got many other cases in the waiting room. You've represented that you've applied. I'm going to trust that you have. Make sure that you send the proof to us within the next 5 days. I'm going to send you out a new hearing date in the mail, okay?
Okay. So what does this mean? This was this be considered like the original hearing or for that next date, or would it be like a second attempt or?
So this is our first pretrial, and because you've represented that you've applied for rental assistance, you get another court date. We're going to send that hearing date to you out in the mail. At that point in time, I'll ask you whether or not you've been able to secure assistance. If we are beyond the 28 days and you have not secured assistance or paid the balance, if there's not some other issue that we need to talk about, the plaintiff will be entitled to a judgment at that point. So it's really important that you're in communication with whoever you're working with, because it's a very small amount of time to get the rent to retain into possession. Okay.
Okay, so like I spoke to them, and so I thought it was being dismissed on the grounds of him being active duty military, and as well as when I first talked to them, I had the payment for the amount of $4,500 that originally I was told that I could send that in directly when I talked to the apartments, but then when I talked to the attorney, they were telling me I couldn't send the $4,500 to them; that it had to be the full 8,000. And so like I said, I wasn't aware. We weren't.
Okay, so ma'am, you still reside in the apartment. You know, the rent's still due and owing. A person who's active in the military, there's not going to be any judgment against the person who is active in the military for the time period that we're talking about here. You are still living in the apartment. The rent is still due and owing. Mr. Morton, regarding the partial payment issue, I know different landlords treat that differently. Is there anything that you wanted to put on the record for Ms. Amos?
In this specific case, Your Honor, correct, was that payment would have been a partial payment, which is why they would not accept that. They would only accept the payment in full. And then secondly, Your Honor, as I think I had communications with this party and advised them that you're right, there is a different protection that's in place when it comes to Mr. Amos, which would be addressed after we address the issues with the assistance payments. But at this time, the case is continuing to move forward.
Can I
So Ms.
state
Amos, just so you
something about
understand,
that payment? Because they actually did accept a
no,
payment.
Ms. Amos, if you want to communicate with your landlord, you're free to do so off the record. We're going to schedule another hearing date for you. I would encourage you to reach out to your landlord if you are trying to work something out with them.
I am, but I want
once
to
you
say about my
end up in the
brother,
court,
his
it's just a matter
dependent.
of enforcing. Ms.
His
Amos, once you're
dependents live
here, okay, all right, we're going to schedule a hearing date for you,
Okay.
and we'll get that to you in the mail. Have a great day.
All right, thank you.
Okay, the next one is Teresa Collins. She has not applied for any rental assistance, but she says she's paid up.
Okay, give me a moment. I just have to get my file to accept the changes to the first file.
Hello, Ms. Collins?
Hi, yes, good afternoon.
Okay, it's gonna be just a minute, okay?
Okay.
All right, this is 240338LT. This is Huntington Park Townhouse versus Collins. All right, Mr. Morton, would you state your name for the record, please?
For the record, Your Honor, Attorney Ian Morton, Appellate's Law P67892 on behalf of the plaintiff.
Ms. Collins, would you state your name?
Teresa Collins.
All right, good afternoon to you, Ms. Collins. This is your first pretrial for non-payment of rent. You do have the right to hire and consult with your own attorney. You have the right to a jury trial if you assert that today or within writing in 5 days and pay the associated costs. You also might be eligible for conditional dismissal instead of a judgment if that's something that you can work out with your landlord and your landlord's attorney. Mr. Morgan, can we start with the balances you have it?
You're at this time, rents retained are $1,635.77. Court costs of $178.43, total of $1,814.20. That's after some recent payments have been made. Was it on the account?
Okay, and Ms. Collins, my understanding is that that you were not in agreement with the balance. Is that correct?
Yes, Your Honor. I paid the balance off in full on the 10th of January. It posted to Huntington Park's website for my account yesterday on the 14th.
Okay, and Mr. Morton, do you have an updated ledger
The information that was
yesterday?
provided would have come in yesterday, but if the court would like to put us into a breakout room after the initial cases, I'm more than willing to speak with Ms. Collins and see if we can confirm if there's any other issues.
All right, are you able to email your client to see if they can confirm payment? I'd hate to bring her back or make her wait if she's already paid.
That's why I'm saying
And here's the receipt.
Hold on, Ms. Collins.
I can reach out to my client. I mean, like I said, if the court wants to take a Ms. Luckoff case, or I can reach out to my client. I think it might just take a minute or two.
That'd be great. All right, Ms. Collins, I'm going to put you in the breakout room, and we'll bring Ms. Luckoff.
Money order receipts.
Hold on, Ms. Collins. The attorney's going to
Somebody
check.
else is
Just give us a
talking.
minute.
Somebody else
We're
is
going to put you
talking.
back in the waiting room.
Okay, I'm not leaving. I'm just letting my employer know I'm a little more detained. Yes, but I did make that payment on the 10th. It posted yesterday.
All
so
right, ma'am, we just need to check. Give us a moment. We're just going to put you back in the waiting room.
Thank you.
Okay. Okay. All right, who do we have?
Okay, let me look here. Got Yolanda Lawson. She's here. She says Antonio Filmore will not be here, and she has not applied for any renewals. Miss Lawson?
Yes. Hello.
Hi, ma'am. Give me just one moment. We have a slow my file system. Just give me a second.
No worries.
All right, this is 2403727. This is the Oaks on Lincoln versus Lawson and Filmore. All right, Ms. Luckoff, can I get your appearance, please?
Good afternoon, Your Honor. Cheryl Luckoff on behalf of the plaintiff.
All right, and Ms. Lawson, would you please state your name for the record?
Yolanda Lawson.
All right, and I see that Antonio Filmore isn't here today. Can you tell me where he is?
He is at work.
All right, I'm going to give you just a moment to reach out to him and call him. He was served. A default judgment can issue against him if he was served and doesn't appear today. So he must appear. So I'll give you just a minute to try to get a hold of him and get him here before we end these proceedings.
I know they can't have their phones at work, and
so I'd like to give you
Okay.
give you at least a chance, because otherwise, Ms. Luckoff, if she asks me for a default judgment today, she's going to be entitled to it. So I would like to at least
Your
give you a
Honor,
chance
because
to-
I can't, I'm not going to ask for it because a half a default judgment isn't going to do me any good.
Well, the problem is next time we get him here, we're going to have to give him his rights, and then he's going to get the adjournment too. So we're going to be 3
you're
years
right.
down the road.
Okay. Okay.
So Ms. Lawson, I'm going to give you just a moment to reach out to him.
okay.
Let me bring in the next one.
That sounds good.
Okay, this is Cindy Wells for Eric Carter.
I'm sorry, who was the original defendant?
Eric Carter. She says she has spoke to you before. And she says she's paid off, so.
All right, this is 2403732. This is the Oaks on Lincoln versus Eric Carter. Ms. Luckoff, we'll start with you.
Thank you, Your Honor. Cheryl Luckoff on behalf of the plaintiff.
All right, so this is our first hearing, and we have not seen Mr. Carter today. Ms. Wells, you're here for Mr. Carter. Can you tell me where Mr. Carter is?
At work.
All right, so he has been served, Ms. Wells. He's got to appear today. Did you want me to give you a minute to reach out to him today?
I can't get him. He's a security guard.
Okay, Ms. Wells, are you an occupant in the residence?
Yes.
Okay. All right, so I am going to give you a minute just to reach out to him. So, Ms. Wells, the reality is this is I know we do this on Zoom. We do this because we believe that it's better for people who are here for a landlord-tenant docket to not have to take off work and to Zoom in. But it is still real court, and he's been served. And if he's not here, Ms. Luckoff here can ask me for a default judgment today for his failure to appear, which means a judgment will issue. So it's very, very important that he be here. I'm going to give you, you're obviously not responsible for him. However, I'm going to give you an opportunity if you'd like to do him a favor and reach out to him and tell him to appear quickly.
Okay, but I have stood in for him before.
Ms. Walls, this is the first time that I've had this case up, so I don't know where that would have occurred, but you cannot stand in for him. He has been served properly by the plaintiff in this case. I'm going to give you an opportunity to reach out to him. If it works out, great. If it's not, I understand that it's not your fault that he doesn't appear for his case. All right, I'll put you back in the waiting room.
And
Okay,
Your Honor,
thank you.
just for the record, he's the only tenant in this case. And he's obviously the only one named on the complaint.
Oh, she's an unknown occupant?
Well, hang on. There is an occupant in there, but she's not a named defendant. I mean, we've served the named defendant.
No,
and
no,
that's who the
I'm just,
Yeah,
I'd
no,
like to do Ms.
but
Wells
fair
a
question.
favor and give her an
Yep.
opportunity to.
Nope, the named
Can I-
occupant on here is Mary Bell.
Can Mary Bill stand in?
Your Honor,
No, Ms. Wells, I'm sorry. I'm asking nicely. If you could just give him a call and let's do the best we can here. I'd love to
Okay.
not have to issue a judgment if I could not, but he's got to be here. There's
Okay, I
still
sure will.
laws. We're still a nation of laws. Maybe just for the next
Maybe
few
not
days
so
here,
much.
but anyways, all right, Ms. Wells, I'm gonna put you back
Okay,
in.
thank you so much. I'll get him.
Okay.
Thank you.
I mean, Your Honor, respectfully, we can go
I
through this
hear
whole
you, Ms.
docket
Flacco.
and.
I'm
Okay,
gonna let you
thank
make that record when she comes back. You can complain then. All right.
Okay, perfect.
All right. Do we have anyone actually ready?
Your Honor, if my other ones aren't, oh, Miss Griffin is actually here. I did see that.
Okay.
He popped in for a moment.
What do you?
Okay, you ready for the next one? I guess Ms.
You'll just
Griffin-
give me a moment. I'm pulling it up on my file. All right. There we go. All right, this is 2403734LT. This is the Oaks on Lincoln versus Joyce Griffin. Ms. Luckoff, can I get your appearance, please?
Good afternoon, Your Honor. Cheryl Walkoff on behalf of the plaintiff.
All right, Ms. Griffin, would you please state your name for the record?
Joyce Griffin.
All right, good afternoon to you, Ms. Griffin. This is your first pretrial for non-payment of rent. You do have the right to hire and consult with your own attorney. You have the right to a jury trial if you assert that today or within writing within the next 5 days and pay the associated costs. You also might be eligible for a conditional dismissal in lieu of a judgment if that's something that you can work out with your landlord in this case. Ms. Luckoff, can I get the balance, please?
Sure, Your Honor. Rent to retain $129.34. Court cost $168. The total redemption figure is $297.34.
Okay. All right, Ms. Griffin, my first question for you was, have you applied for rental assistance in this case?
Okay, well, first of all, these amounts were not given to me.
So, Ms. Griffin, we're going to get to that. I just need to know right now, did you apply for rental assistance?
No, because my rent is paid up.
Okay. All right. So you have no intention of applying for rental assistance. Is that correct?
No, I had to.
Okay. All right. Let's talk about that balance because it looks like it's pretty low. Ms. Griffin, when was the last balance? When was the last payment that you believe you made?
On the 3rd.
Okay. And how much was that for?
$14.50.
And does your ledger reflect that, Ms. Luckoff?
I see a payment of $14.20 on January 3rd. There was a balance at that time of 200, well, with the court cost, $201.29, and then late fees have been assessed because there was still a balance.
All right, I'm sorry, you said the balance was the 201 and then there was late fees on top of that?
And that included, I'm just looking here, yeah, because I think sometimes these residents, there's a utility charge that's in here. She can get a copy of her ledger if she has any questions about this.
What? I paid 1,800 a couple of months ago. So
Wait, you just
I-
said you paid $14.50 and I responded and
So wait,
said you
hold
paid
on.
$14.20.
So hold on. So Miss Griffin, Miss Sluckoff, I think you're just a couple $30 off of what you believe that you paid on the 3rd. You said $14.50. Miss Luckoff reflects a $14.20
Okay.
balance as of January 3rd. So whatever you paid a few months ago, it looks like this was just a December rent case. Am I correct, Miss Luckoff?
No,
Well, I mean, there's, Your Honor, there's been a balance, I mean, forever.
Okay.
They're usually small. I mean, she should get, what I would recommend is she goes and gets a copy of her ledger and she can talk to the manager if she has any questions, but that's the balance that I'm showing.
okay, can I explain?
6
Please.
months,
Yeah, go ahead,
you
Miss
know.
Griffin.
Okay, now, when I got this letter, this first letter saying that I owed 188 or whatever it was, I called Lori, the property manager. I received it on a Saturday, I think on the weekend. Left her a message, she didn't answer. I called on Monday. I asked her what's going on with this 188. Because in between this time, well, first of all, so she put me on hold and she came back and said it was 6 months. It's been going on for 6 months. This was from 6 months ago since May. Apparently, I was paying $30 less per month. When she was on vacation, after I signed my lease on March the 8th, 2024, for $12.99 for my rent, including the dogs, I got another letter like in June or something saying I was $20 or $30 short. I called the office. Lori wasn't there. I spoke to another lady and asked her, tell me what my rent is, because apparently there's a misunderstanding. And I said, and is this including the dogs? She told me $12.99. I said, and I joked, I said, it might as well be $1,300 even, because last year it was $1,224. So, I get the discounts or whatever I get for, whatever I get, whatever. So my rent for what I signed on March 8th was $12.99 a month, including the dogs. Apparently, that was wrong on their part. I was paying what the lady told me to pay after I spoke with her. She put me on hold and I asked her, was that including the dogs? She said yes. So
I'm sorry, you're saying that the amount on your lease is wrong and that you had a separate agreement with your landlord?
I signed for $12.99. That's what I signed the lease on. Is that supposed to change if I sign it?
All right, so Miss Luckoff, I am in my file. It's going to take me just a second to pull it up. Do you have the lease in front of you?
I can grab it.
I'm pulling it up now.
And then I paid, after I talked to Lori, I told her I had to get my paycheck first. And I paid it. I think what happened on Saturday, I went to Walmart and their system was down. Sunday, I didn't have my car. So I went, I think it was either Sunday night or Monday night, I went to CVS. I had to pay cash and I gave him $200 and I paid the $188. Then 2 weeks later, I get this eviction notice. So I'm thinking, okay, now I paid this like 2 or 3 weeks ago, but I knew this was going to happen because she does this.
All right, hold on. I've got your lease agreement here, ma'am. Hold on. Let's see. I'm showing Oaks on Lincoln, rent $9.99 first year, and then
and she sends the first rent agreement all the time. It's changed. I've been here 7 years. She does.
Wait, hold on, Miss Griffin. Just give us a minute. We just want to make sure we're all working the same information.
I'm sorry.
No, you're fine. You're fine. Are you looking at it too, Miss Luckoff?
I'm trying to, so bear with me. Griffin, I just had it when I had the other gentleman's Eric's up, but here we go. Okay. All right. All right. Home monthly rent. All right, that's an old lease. So let's see if we need a renewal. Yeah, I mean, this is a very old lease.
Yeah, the only one I have.
I'm sorry, I didn't mean to interrupt you.
No, the only one I have shows $9.99.
Yeah, I mean, do you want me to call the client? I mean, it's
All
the
right,
first
so
hearing.
it looks like there's an issue with she's disputing it anyways. So I'm going to give her a second hearing, Miss Griffin. Make sure that you go and take a look at the ledger, Miss Luckoff, just given what we have attached here with this lease and what's been placed on the record. Also confer with your client before the next hearing.
Oh.
All right. In the meantime, Miss Griffin, I can also give you a little more. Did you want to apply for any rental assistance? Because if you do, I can give you some information.
Well, why do I need? I mean, I'm not late on my.
You don't have to. I'm just asking. Would you like the information or not?
They're not gonna give it to me anyway because I have to be 2 months behind. I gotta be. I'll have to do all this stuff again before I get.
I just like to ask, Miss Griffin, if you want it, I'll give it to you. The other, if for Lakeshore, we have Lakeshore Legal Aid that appears sometimes in some of our hearings, but they're not here today. But if you'd like to reach out to them to see if you qualify for free legal counsel, I can't promise that you do, but if you'd like that information, I can also provide that to you.
Okay, and also I would like to get a number or any way I can contact. I guess it's the law board.
Miss Griffin, hold on. We need to do one thing at a time here.
I you want? I forget.
Oh no. Okay. Did you want the number for Lakeshore Legal Aid or the email for them?
Yes.
Okay. Ready?
Yeah.
So it's going to be Oakland Housing at lakeshorelegal.org. I'm going to spell that for you. It's OAKLAND HOUSING. So Oakland Housing, and then the @ symbol. LakeshoreLegalAid.org. Lakeshore is LakeshoreLegalAid.org.
Okay. Oakland Housing at lakeshorelegal.org.
Yes, ma'am. All right. We're going to schedule you a new hearing in the mail. You'll get that date in the mail. And Ms. Luckoff, if you just check on that lease, please. We obviously have the incorrect one. And Ms. Griffin, make sure you're following up about the balance, okay?
I heard several people complain in the apartment complex about the same thing. I don't know if this.
So Ms. Griffin, I'm not here for a class action. I'm just here for your case today. So just make sure that you follow through the landlord. Okay.
Don't I have a right to regress my grievances to the government?
You do, but we're not at that phase yet. We're still trying to get the numbers right. All right.
But that's at another hearing, correct?
Correct.
Okay.
All right. Good luck. I'll see you back. We'll send you a date in the mail. All right. Give me just a moment. I've got to update this. Yeah, so Ms. Luckoff, just so you know, going forward, now that everything is moving onto my file, I don't know if you probably can't, your system is probably completely different from what I have, but the way it works is that I don't just have access to everything that's been filed. I have to go into it. And so just FYI, you might want to just going forward have some of this information where I used to just be able to pull up the sheets. I can't do that anymore. Okay. So everything is slower. All right. Okay. All right, Mr. Carter, I see you there. Can you hear me?
Yeah, I can hear you. Can you hear me?
Yes. Neil, did you need something?
I was going to say.
Okay, we've got Mr. Carter here. This is 2403732. This is the Oaks on Lincoln versus Carter. Mr. Carter is here now. Ms. Luckoff, may I get your appearance?
Cheryl Luckoff on behalf of the plaintiff.
All right, and Mr. Carter, would you please state your name for the record?
Ronaldo Carter Jr.
All right, did you get that? All right, Mr. Carter, would you just repeat again? Your audio is jumping a little.
Eric Ronaldo Carter Jr.
All right, good afternoon to you, sir. This is your first pretrial for non-payment of rent. You do have the right to hire and consult with your own attorney. You have the right to a jury trial. If you assert that today or within writing within the next 5 days and pay the costs, you also might be eligible for a conditional dismissal instead of a judgment. If that's something that you can work out with your landlord in this case. Ms. Luckoff, can I get the balance as you have it?
Sure. The total amount due, including court costs, $2,380.24. May I just clarify that this is Eric Carter, because the first name wasn't sounding like Eric to me. So
Yeah. Yes, I am Eric Carter. This has
Okay.
development.
All
So
right. No worries.
I got Eric.
Sure.
All right.
Okay.
Okay.
Thank
And
you.
Ms. Wells is not joining us anymore. All right, Mr. Carter, do you agree with the balance as Ms. Luckoff stated it?
yes, I do. I just had trouble paying because I tried to sell an online payment thing, and it got all jumbled together. So I would make my payment today by the end of business, or before end of business.
Okay, you're saying that you have the full amount today.
Yes, I do.
And why did you have trouble paying it?
All right, so it was this online payment service called FedEx, and I was trying to use their service, and they tangled up my payment. And so when I paid them to pay my bills, it didn't process. And so I had to wait for my money to come back to me to a refund before I could pay my landlord. I talked to my landlady and explained this to her already about this.
Okay, so your landlady had sent Ms. Luckoff to collect today with the judgment. So obviously,
it's automatic. Like if I miss my payments, it automatically goes to the lawyer.
do you mean you're getting shut out of the portal, or?
No, it's.
Oh, you mean the case goes to the lawyer if you miss your payment? Okay, I'm sorry,
Yeah.
I didn't quite understand what you're saying. Okay, all right. I do have to ask. I know you're telling me you have the rent, but were you going to be applying for rental assistance?
No, I was not.
Okay, all right, Ms. Luckoff.
Well, Your Honor, I would do this. You said, sir, you're going to pay this today?
Yes, it just cleared in my account last night after business hours. So I got the rent back now. I'm about to make the payment soon as I get down here.
I mean, Your Honor, what I would ask is, I'm certainly willing to give the courtesy if he's going to pay this today. But if not, I would ask for judgment that if we could enter a judgment tomorrow if we don't receive payment today.
All right, the problem is I have to give him his appellate rights too. All right, so Ms. Luckoff, if you want to enter into judgment today, would you agree to set it aside if he pays it today?
Yeah, I mean, I wouldn't even submit it to you. I mean, I would say
Then,
judgment.
yeah, then I'll just get the dismissal.
Oh.
Got it.
Yeah.
But let's just
Yeah.
do that so that I can at least give him his rights if it does get
That's
sent
fine.
in, and if not. Okay, all right, so Mr. Carter, what's happening here? Ms. Luckoff is entitled to a judgment today. So I'm going to issue a judgment for possession only. The rent retained. Yeah, the rent to retain will be $2,380.24. However, Mr. Carter, if you do pay it today, she's not going to send that in to me, and this case will be dismissed. So you won't have a judgment. So make sure that you pay it today. Otherwise, Ms. Luckoff is going to be able to send that to me tomorrow, and I'll sign it.
I have a quick question. I don't believe that's the right payment. I had made a $400 payment the other day, and I don't think that's up to date. So I'll check with my landlady to update the balance, but I'm pretty sure I paid $400. It's just the $2,000 that I need right now.
All right, so the judgment's going to be for the amount that's stated on the record, Mr. Carter. A lot of times tenants think that they've made a payment that hasn't been accepted or didn't go through. I don't know what the case is, unless Ms. Luckoff, are you taking a look at that ledger? Can you tell me it was confirmed?
So $410 was paid on December 31st. That is credited. There has not been a payment since that time that I see on the ledger.
Okay, so Mr. Carter, just so you know that the amount is the $2,380.24. Make sure that that's paid today. Otherwise, I'll sign the order that she sends. Do you understand?
All right.
You also will have 10 days to appeal from the entry of the order. Anything else for the record?
No, that's it.
Not
Thank you.
complaining. Thank you.
All right, good luck, sir.
Do I just leave?
Yes, you're free to go.
Ms. Lockoff, I'm going to bring in this Miss Bridges. She says she's already moved out, but she just needs to.
Boy, it's quite a day here.
So I
Oh, you
told
have
you.
no idea.
I warned you.
This
You
morning
did.
is on
You did.
fire. Yeah. Let's see.
Oh, Miss Bridges.
Nobody. Okay.
Hi, Miss Bridges. Can you hear me?
Hi, yes, I can hear you now.
Okay. All right. Let's see. This is 2403733LT. This is the Oakstone Lincoln versus Bridges. Ms. Lockoff, may I get your appearance, please?
Good afternoon, Your Honor. Cheryl Luckoff on behalf of the plaintiff.
All right, Ms. Bridges, would you state your name, please?
Yes, April Bridges.
All right, Ms. Bridges, this is your first pretrial for non-payment of rent. You do have the right to hire and consult with your own attorney. You have the right to a jury trial if you assert that today or within writing within 5 days and pay the costs. You also might be eligible for conditional dismissal instead of a judgment if that's something that you can work out with your landlord and your landlord's attorney. Ms. Luckoff, can I get the balance, please?
Your Honor, total amount due is $4,325.42.
Okay. And Ms. Bridges, do you agree with that balance?
Yes.
All right. And what was your plan regarding the balance?
My plan is because I did, this is the last week I'm moving the rest of my things out because I did get a PPO and trying to get away from my child's father. I don't mind paying the balance if I can get on a payment plan because I would be completely out by the end of this week.
So hold on, Ms. Bridges, and I don't want to,
Yeah.
I don't want to dig into your personal information too much. There's a couple other questions I have here. The person that you're seeking the personal protection order against, does that person reside with you?
No, not right now.
Okay, so does that person, did he reside with you? Does he have stuff at your home? What is the contact with that person?
He did have stuff at the home that I was at that address.
Okay, did you have anyone else on the lease, Ms. Luckoff, or was he living there?
Let me take a look again.
The other person?
The Bridges.
Ms. Bridges, what was his name?
Gerald Arraignment.
Would you spell that for me?
JURREAUALDRICH.
All right, let me take a look for April.
He wasn't
And
on
she's
there.
the only one that there are two occupants. There's April Bridges is the named tenant, and then it looks like there are some children. Desiree and Derek Shaw, and those are the only ones on the lease, Your Honor.
Right.
Okay, so this person, was he previously living with you?
Yeah, he did move his stuff in. I wasn't able to put him or the new baby on the lease at the time.
Okay. And I'm so sorry. I know you tried to spell, but JURREADGE?
No, JURREAU. And then last name is Aldrich, ALDRICH.
Okay, it looks like we have him also in our waiting room.
He's not here.
Oh, he isn't? He was there.
Okay.
Oh, okay. He might have left. He was wondering how he gets his stuff back.
Okay. Okay, ma'am. So you stated you're in the process of moving out. What is your plan for, you don't have to tell me where you're going, but when are you planning on being out by?
I can be totally out at least by next week. If I can bring in the keys.
So, Your Honor, as
All
you
right.
know, this is possession. Go ahead.
Go ahead.
Sorry. I was just gonna say this possession only, so if we can just go with the statutory redemption period and take a judgment, as long as Ms. Bridges, you can be out by the 24th.
Yes, that's totally fine.
So just hold on 1 second, Ms. Lockoff. All right, Ms. Bridges, were you planning on applying for any rental assistance? Although you've told me you're moving, you're not out quite yet. Were you applying for any rental assistance?
Yes, I can apply for rental assistance.
You did, or you're going to?
I'm going to. I didn't at the moment.
Okay, and so do you need the information for that?
Yes, please.
Are you ready to take it?
I'm grabbing a pen now. I'm ready.
All right, so the number for the Housing Resource Center for CHN is 248
Mm-hmm.
269
Yes.
1335. Again, 248 269 1335. You want to read that back to me?
Yes, 248-269-1335.
All right, and I also have an email for free legal counsel. I don't know if you qualify, but if you'd like to be screened by them, I can provide you with that also.
Yes.
All right, and this organization will also can assist with personal protection orders. They have a couple different divisions. The one I'm giving you is for housing. So it's going to be Oakland Housing. So OAKLAND HOUSING, the @ symbol. And then Lakeshore, LAKESHORE, legal, LEGAL, aid, AID.org.
Okay.
You want to read to me what you have?
Yes, Oakland Housing at lakeshorelegal.org.
Correct. All right, since you've represented, you'll be applying for rental assistance in this case. I'm going to give you another hearing that will come to you in the mail. So make sure that if you do move on the 24th, that you provide us with a new address so we can make sure that we get you the information so you don't have a default judgment issue against you.
Okay.
All right.
I'd just like to place an objection on the record. I think when a defendant indicates that they are vacating the premises, that the 2-week adjournment would not apply.
All right, well, she's not out yet. So she decides to stay. She's going to submit to the court within the next 5 days that she's applied for rental assistance. You must submit proof to the court within the next 5 days that you've applied. It does affect the timing of your case. At the next hearing, just to understand, the plaintiff will be entitled to a judgment. So it's very important that if you are trying to seek rental assistance to stay in the property, that you make sure that you submit within the next 5 days and work to secure that. Otherwise, if you're out, Ms. Luckoff, everybody wins. Okay. All right. All right, Ms. Bridges. Right. Anything else for the record?
No, ma'am.
All right. Good luck, Ms. Bridges.
Okay. Thank you.
Miss Lawson's out there too, that she was supposed to check where Mr. Filmore was at.
I think that's my last one.
I think so. He was trying to reach Mr. Filmore.
All right. Any luck, Miss Lawson?
No.
Okay.
And
all
he
right.
hasn't, because he hasn't been here, so I didn't even give him the papers because he hadn't been here. So I just thought that it would do. He just hasn't been. That's what I was trying to say before. He hasn't been staying here for a while.
How long has he been gone?
I think before October. Before he's been gone. So I didn't.
All right.
But I still tried to reach him to see if he could still come on, but I couldn't. I couldn't reach him.
Ms. Look, if I'm just pulling up the digital file, current service.
Oh, sorry. Sorry.
All right, this is case number 2403727. This is the Oaks on Lincoln versus Lawson and Filmore. Miss Lockoff, can we get your appearance, please?
Okay.
Cheryl Lockoff on behalf of the.
All right, and Miss Lawson, would you please state your name for the record?
Yolanda Lawson.
And we have not seen Mr. Filmore today. Good afternoon to you, ma'am. This is your first pretrial for non-payment of rent. You do have the right to hire and consult with your own attorney. You have the right to a jury trial if you assert that today or within writing within 5 days. You also might be eligible for something called a conditional dismissal instead of a judgment if that's something that you can work out with your landlord. Ms. Lukoff, could I start with the balance, please?
Sure. Your Honor, the total amount due, including court costs, is $1,490.12.
All right. And Ms. Lawson, do you agree with that balance?
Yeah, because you had $14.90. Okay, because I had
That
14.
includes your court cost, but yes, your rent before the court cost was $1,286.12.
Yeah, because I had $14.96, so it's $14.90. Okay.
And Ms. Lawson,
Yes.
do you plan on applying for any rental assistance in this case?
I didn't know where I could apply, and
so I can provide you with some information if it's your plan to do so.
Okay, because I didn't know where to apply, and I was just going to pay the remainder balance by the 27th.
If you can pay it, you should pay it. Okay, so here's the deal. Ms. Lawson, if you're applying for rental assistance, you're entitled to an adjournment so long as you send proof to me within 5 days that you've applied. If you are not applying for rental assistance today, Ms. Lukoff is entitled to a judgment.
Okay, I can try to see where I can apply for rental assistance. I don't want to get a judgment. I just want to be able to pay my balance.
But you actually have to apply and send proof in to me.
Yeah, no, I understand that.
Okay.
So what do I have to bring it into court, or where do I?
I'm going to give you that information right now.
Okay.
All right. So first, let me give you the number for the Housing Resource Center. This is through CHN. That number is going to be 248-269-1335. Again, 248-269-1335. Want to read that back to me?
Yes, 248-269-1335.
Correct. And then you're going to, within 5 days of today, make sure that the court receives proof that you've applied. There's a form you can fill out that you'll get, or you can just screenshot it and send it to me. I'll take that too. But you're going to send that to civil@45dc.org. Civil is spelled C as in cat.
CIVIL.
Civil. Yep. Okay. You'd be surprised how many people miss that.
That's okay.
And send it to the wrong place. Okay. So great. Civil@45D as in district, C as in court.org.
Districtcourt.org. Okay. Am I putting the TH for 45 or just?
Nope. 45? Just at 45dc.org.
Oh, DC.org. Oh, so I'm not spelling out district court, just DC.org.
Correct. And I'm going to send you a new hearing date in the mail. Here's the deal though. If you pay your rent, what happens, Ms. Lukoff?
If you pay the rent, the case will be dismissed.
All right. But Ms. Lawson, if we send you a new court date, make sure you show up. Sometimes tenants think that they paid and there's some sort of disagreement. And if that happens and you don't show up, then Ms. Lukoff is entitled to a default. So make sure that you show up if you get a date from us. All right. We need to handle Mr. Filmore, Ms. Lukoff.
I would request the entry of a default judgment as long as you see service by attachment. Obviously, they would not have been able to personally serve him if he's not there. The full balance rent to retain is $1,286.12. The court costs $204. The total amount to $1,490.12. The statutory redemption period would be the 24th. Obviously, we can't necessarily accomplish that, but I am asking for entry of a judgment today by default, possession only.
All right, default judgment for possession only against defendant 2, Filmore. Rent retained for the amounts placed on the record. The rent can issue on January 24th. You do have appropriate service. All right. You're all set, Ms. Lawson. Make sure we get that within 5 days, okay?
Okay, thank you.
Great day.
You too. Thank you, ladies.
Thank you. Thank you, Your Honor.
Have a great day, Ms. Lukoff.
You too.
All right, we've got Ms. Collins back.
Oh, wait, that's not mine, is it? Okay, no, I'm good.
You're good.
Mr. Moore.
Miss Collins, any luck?
Your Honor, actually, I had spoke to my client about Miss Collins, if you remember.
Oh, good. Okay. Give me one moment to get back into the file. Okay. Okay, recalling 240338, Huntington Park Townhomes versus Collins. All right, we're back on the record. Mr. Morton, did you confer with your client?
I did, Your Honor. At this time, we'd move for dismissal without prejudice, and we'll submit that dismissal when I'm done with court today.
All right, ma'am, this case will be dismissed without prejudice. Have a great day, Ms. Collins.
Thank you. You too, Your Honor.
All right. Do we have anyone else?
Essence, Graham's coming in.
Did we have an arraignment we needed to do?
I told him we'd call him when we're done.
Ooh, okay.
And I talked to Miss Costello. I told her I'd give her a buzz too when we're ready.
Okay, sounds good. Who are we bringing in?
Graham? Miss Graham?
Yes. I'm sorry, here I am.
All right, this is 2403. Oh, yes, just let me know when you're ready. All right, this is 240339. This is Huntington Park Townhomes versus Graham. Mr. Morton, could you state your name, please?
For the record, Your Honor, Attorney Ian Morton, Pallets Law, P67892, on behalf of the plaintiff.
All right, Ms. Graham, would you state your name, please?
Essence Graham.
All right, good afternoon to you, Ms. Graham. This is your first pretrial for non-payment of rent. You do have the right to hire and consult with your own attorney. You have the right to a jury trial if you assert that today or within writing within the next 5 days and pay the associated costs. You also might be eligible for a conditional dismissal instead of a judgment if that's something that you can reach an agreement with your landlord and your landlord's attorney. All right, Ms. Morton, let's get that balance.
You're at this time, rents retained is $7,109.43, core costs of $178.43, for a total of $7,287.86. It's a possession only action.
Okay. All right, Mrs. Graham, do you agree with that balance?
Slightly, I was showing something slightly different, in the 6,000 range, but that could be without the associated late fees, and then of course the court fees as well.
Okay. All right.
Your Honor,
Were you
I'd say
applying
that
for?
I'm sorry, I was going to say, Your Honor, that is inclusive of court costs, late fees, and the month of January.
Okay, so that would make sense to me.
Okay. All right. And ma'am, were you going to be applying for any rental assistance?
So I have been trying to apply for rental assistance. Previously, the issue was my income. However, I was having like a mental health situation that was affecting me at work, and then it ultimately caused me to lose my job.
All right. So Ms. Graham, you said that you've previously applied. Are you going to be applying in this case?
I mean, that's what I'm referring to. So it was for this case.
Okay.
So I have applied, but like I said, I was denied before and I've applied again. But I haven't heard anything back.
Okay. Where are you waiting to hear from?
Community Housing Network.
Perfect. Okay. All right. Since you've applied and you're waiting to hear from them, I just need proof that you've applied within the next 5 days sent to me. That must get here within the next 5 days. You can screenshot your confirmation if you want, or you can fill out the form and send it to us. Let me give you your email. Let me give you our email.
Okay.
You ready?
Yes.
All right. So it's going to be civil@45dc.org. Civil, CIVIL, at 45dc.org. Civil is C as in cat, I as in igloo, L as in log, I as in igloo. Oh, you missed it. Oh, what's happening? Oh my goodness, it's been a long day. All right, let's try this again. Are you ready, ma'am?
Yes, I am.
Whew. All right, we've done this too many times today. All right, so C as in cat, I as in igloo, V as in Vaz, I as in igloo, L as in log, at 45D as in district, C as in court.org.
Okay.
You wanna read that back to me?
So I have it civil at numeral 4 5, D as in district, C as in court.org.
Yes, just make sure that we get that proof within the next 5 days. That does affect the timing of your case.
What's your case number?
And please make sure that you put your case number on that form that you send us, okay?
And can I have the case number?
Yes, you ready? It's on your paperwork, but it's 240339LT.
Okay, thank you. I'll check the paperwork as well.
All right, we'll schedule that hearing date. It'll come to you in the mail. Good luck.
Thank you.
All right.
Can we poll?
Yeah, I hate that I can't get. All right, this is 240334LT. This is Huntington Park Townhomes versus Higs. All right, Mr. Morton, let's get your appearance.
Attorney Ian Morton, Appellate's Law, P67892, on behalf of the plaintiff.
All right, and Mr. Higgs, would you please state your name?
Ricky, R-I-C-K-Y, Higgs, H-I-G-G-S.
All right, good afternoon, Mr. Higgs. This is your first pretrial for non-payment of rent. You do have the right to hire and consult with your own attorney. You have the right to a jury trial. If you assert that today or within writing within 5 days and pay the costs associated with that, you also might be eligible for a conditional dismissal instead of a judgment, if that's something that you can work out with your landlord in this case. Mr. Morton, what is the balance?
Your Honor, with Mr. Higgs, rents retained, $5,954.54. Court costs, $178.43, for a total of $6,078.97. Possession only action.
Okay, and do you agree with that balance, Mr. Higgs?
Yes.
Were you going to apply for rental assistance?
I just found out about rental assistance, so I would do it as soon as I get off.
Okay, so here's the deal. You apply for rental assistance. You must provide proof to us by email that you have done so within the next 5 days. It does affect the timing of your case. We have to have that proof within 5 days. I'm going to give you an email in just a second. Do you have the number for the Housing Resource Center for Oakland County?
No.
Are you ready to take it?
Let me grab a pen. I got a piece of paper. All right, I'm at work. Okay, I'm ready.
All right, that number is going to be 248
Yes,
269
yes,
1335.
yes. Okay.
Read that back to me, please.
248-269-1335.
All right, and then within the next 5 days, it's got to be within the next 5 days.
Okay.
Send us proof that you've applied. There's a form that they'll give you when you apply that you can send into the court. I'll take a screenshot confirmation too. That's just fine. Just make sure you put your case number on it, case number like this case number, and then you're going to email that back to the court at civil@45dc.org. I'm going to spell that for you. C as in cat, I as in igloo, V as in vase, I as in igloo, L as in log, at 45D as in district, C as in court.org.
Okay. Civil@45dc.org. .org.
Correct. You want to spell civil for me? I just want to make sure you got the right spelling.
CIVIL.
Correct. All right. Just make sure you put your case number on it. Send that in to us. We're going to send you a new hearing date in the mail. Make sure you're looking for it. All right. Anything else for the record from either party?
No, Your Honor.
No.
All right. You're all set for today, Mr. Higgs. Good luck.
Okay.
All right. What else do we have here?
Elisa Jones.
Hello, Ms. Jones. Ms.
Yes.
Jones?
Yes.
Okay, 1 minute, ma'am.
All right, Ms. Jones, this is 24-0334LT. This is Huntington Park Townhomes versus Jones. Mr. Morton, can I get your appearance, please?
Attorney Ian Morton, Appellate's Law, P67892 on behalf of the plaintiff.
All right, Ms. Jones, would you state your name, please?
Elisa Jones.
All right, Ms. Jones, good afternoon to you. This is your first pretrial for non-payment of rent. You do have the right to hire and consult with your own attorney. You have the right to a jury trial if you assert that today or within writing within 5 days and pay the associated costs. You also might be eligible for conditional dismissal instead of a judgment if that's something you can work out with your landlord in this case. Mr. Morton, can I get the balance as you have it?
Rents retained, $5,426.97. Court costs, $178.43. Total $5,605.40. This is inclusive of the month of January.
All right, Ms. Jones, do you agree with the balance?
I know that probably is my balance. I wound up losing my job. I just got hired in at Henry Ford Hospital. I'm here right now. I just had to come in the bathroom.
Okay, so Ms. Jones, hold on a second. There's we got a couple layers here before we get to the reasons. Any payment plan you're looking for, that's between you and your landlord. Obviously the plaintiff is here. Hold on, seeking a judgment today. I just need to first make sure, do you agree with that balance?
Yes, that's the right balance.
All right, so are you going to apply for any rental assistance in this case?
I have $2,000 in cash, and I reached out to the Salvation Army, but they said unless I'm on my last 1,000, that's when they'll help me pay the 1,000, because they're only giving me 1,000.
Okay, so ma'am, hold on, this is important. If you want to apply for rental assistance through Oakland County, I will give you an opportunity to do so, but you have to apply. You have to apply immediately, and I need proof that you've done so within the next 5 days. As long as you send me proof that you've done it, you get a 28-day adjournment to secure that rental assistance. If you are not seeking rental assistance through Oakland County today, Mr. Morton is entitled to a judgment. Are you going to be applying for rental assistance?
Yes.
All right. Can I give you the number to call?
Yes. I can put it on my phone. I'm ready.
All right. So that number is going to be 248.
Okay.
269.
269.
1335.
248-289-1335.
Nope. Let's try again. It's 248-269-1335.
248-269-1335.
You got it. All right. And now the next part of this, just as important, after you've applied, you must send proof to the court within the next 5 days. As proof that you've applied, put your case number, this case number on it, and then you're going to email it to the court. Are you ready to take our email?
Yes.
All right. Our email is going to be civil@45dc.org. So that's going to be C as in cat, I as in igloo, V as in Vass, I as in igloo, L as in law, at 45D as in district, C as in court.org.
.org.
Yes, ma'am. All right, I'm going to schedule a hearing date for you. Make sure that you're looking out for that. We'll expect to get the proof that you've applied within the next 5 days. If you are trying to work out a payment plan with your landlord, Mr. Jones or Miss Jones, that is going to be between you and your landlord. Just know that the next time we come back here, if you secure rental assistance, that's great. If you did not secure rental assistance, Mr. Morton will be entitled to a judgment. So this court can't force the plaintiff into a payment plan. That's between you and your landlord. So make sure that if that's what your goal is, that you're communicating with them before you come back to court. Okay.
Okay. Okay.
Any questions?
No, thank you so much.
All right. Good luck, Ms. Jones, and good luck at your job.
Thank you.
All right. Do we have anyone else ready?
Alan was the one that was having audio issues. He's still here, and then Dominique Ewan is here.
Okay. So Graham, let's bring Graham back in.
Mr. Allen?
They also have not a training variety back.
Mr. Allen?
Thanks, Graham. Mr. Graham?
Alan. We did Graham. It was the lady.
Why is it still here? Hold on.
Mr. Allen, can you hear me?
Yes, I can hear you.
All right, hold on just a second. The judge will be with you, okay?
Okay.
We had a hard time hearing you the last time you were here.
Here, can you hear me better now?
Yeah, I can hear you good now.
Okay.
All right, we've got Mr. Allen back. Mr. Allen, can you hear me?
Yes.
All right, this is case number 2403335LT. This is People versus Gino Allen. Mr. Morgan, can I get your appearance, please?
Your Honor, Attorney Ian Morton, Powell's Law, on behalf of the landlord.
All right, Mr. Allen, please state your name.
Gino Allen.
All right, Mr. Allen, this is your first pretrial for non-payment of rent. You do have the right to hire and consult with your own attorney. You have the right to a jury trial if you start that today or within writing within the next 5 days and pay the costs. You also may be eligible for a conditional dismissal instead of a judgment if that's something that you can work out with your landlord and your landlord's attorney. Mr. Morgan, can I get the balance?
Your Honor, at this time, rents retained is $3,076.11. Core costs of $178.43 for a total of $3,254.54. Possession only, and this does include the month of January.
All right, Mr. Allen, do you agree with that balance?
Yes.
And are you going to be applying for rental assistance?
Yes.
Have you already done so, or do you need the information?
I'm sorry, you were breaking up.
Have you already applied, or do you need the information?
I need the information.
You ready to take it down?
Yes, ma'am.
All right. So for the Housing Resource Center for Oakland County, that number is going to be 248-269-1335. Can you read that back to me?
248-269-1335.
All right. And now the next part of that is once you've applied, you must submit within the next 5 days proof that you've applied. They'll give you a form. I'll also take a screenshot of the email that they send you showing that you applied. Just make sure that you put this case number on it when you send it back to us. You're going to email it. You ready to take that email?
Yes, ma'am.
All right. That email is going to be civil@45dc.org. I'll spell that for you. C as in cat, I as in igloo, V as in vase, I as in igloo, L as in law, at 45 D as in district, C as in court.org. Do you want to read that back to me?
Okay, civil at 45dc.org.
Okay. All right. Any questions?
No, should be okay. Actually, I do have a question.
Yeah.
So if I just paid the whole thing, would I be okay? Or
So, Mr. Morton, if he pays off that balance, what will happen?
Then he will receive a dismissal.
Okay, so
Okay.
Mr. Allen, here's the deal though. If we do send you a hearing date, make sure that you appear for it. Sometimes tenants think they've paid it and they end up something has gone wrong and then default judgment issues against them. So if you get a date from the court, make sure you come back to the court, okay?
Okay.
All right. All right. Good luck, Mr. Allen.
All right, thank you. How about this?
All right. Who else do we have?
Dominique Union.
Miss Union?
Hi.
Hi, Miss Union.
Oh, wait,
Okay.
can you see me?
I can't see you, but I can hear you, and that's just fine. Oh, now I can see you. All right. All right, ma'am. Good afternoon to you. This is case number 2403349LT. This is Huntington Park Townhomes versus Union. Mr. Morton, can I get your appearance, please?
Attorney Ian Morton, Pallets Law, P67892 on behalf of the plaintiff.
All right, and Miss Union, would you state your name, please?
Dominique Union.
All right, good afternoon to both of you. Miss Union, this is your first pretrial for non-payment of rent. You do have the right to hire and consult with your own attorney. You have the right to a jury trial if you assert that today or within writing within the next 5 days and pay the costs. You also might be eligible for conditional dismissal instead of a judgment if that's something you can work out with your landlord and your landlord's attorney. Mr. Morton, can we start with the balance?
Rents retained $2,568.61. Court costs of $178.43. We're told $2,747.04. This is inclusive of the month of January, and this is a possession only action.
All right, Miss Union, do you agree with the balance?
Yes. Okay, wait, you said there's a court fee too?
Yes, there's a court fee included in there.
Okay.
And are you going to be applying for any rental assistance in this case?
No.
All right, what is your plan regarding the balance?
So basically, I'm just about caught up. I'm gonna make another payment either Friday or next Friday when I get paid, so I can possibly just pay the rest off.
Okay, so Ms. Morton, obviously I'm going to give her the spiel here in a minute. I don't know if you wanted to possibly structure some sort of settlement if she's got a plan. I'll leave that up to you. I can give her the rental assistance information.
I was going to say, Your Honor, if the court wants to give her the spiel, okay. I can also say that we can extend the payment date out to the 30th.
Okay. All right. So, Ms. Union, here's the deal. If you tell me that you're applying for rental assistance in this case, I'll give you that phone number, and then I'm required to give you some time. You get 28 days as long as you send in proof that you've applied. If you don't do that, what happens today is that Mr. Morton is actually entitled to a judgment. Were you going to be applying for rental assistance?
No. Because I don't need it. Yeah, because I really don't need it. It's just like life happens.
You know, the reality is you can't pay it in full today. And I have an attorney in front of me who's entitled to a judgment for the full amount today.
Today.
Yes.
Oh. Okay, so.
I was about to say, but Your Honor, I would say, but she does have the opportunity to redeem and stay if she makes the payment, of course.
But then she has the judgment on her record.
Correct. That's correct, Your Honor. I just want to make sure she doesn't think that we're going to get a writ today. That's all. I want to make sure she doesn't think that.
Okay, so can you explain this one more time? This is the first time I've been through this.
That's it. So, Ms. Union, if you tell me you're applying for rental assistance and you actually do and send the proof to me within the next 5 days, I am required to give you 28 days to get that assistance. If you are not seeking help in any way, shape, or form, Mr. Morton here is entitled to a judgment, which means that there would be a judgment for possession only, which means that a writ of eviction could enter within the next 10 days if you don't pay the full amount within the next 10 days.
Okay. So I can pay it in the 10 days. So I can apply for it. I know for sure I don't
wait,
need
Miss
it. That's the
Union. Okay,
confusing
sorry.
part.
I'm not allowed to give you legal advice. Just
I know,
listen.
I'm so
If
sorry.
I issue a judgment today, you will have a judgment on your credit history.
Oh, okay. No, I don't want that. Okay.
So
Okay,
you want
okay.
to apply? Did you say you wanted to apply for rental assistance?
Yes.
Let me give you that number and make sure that you do and that you submit the
Okay.
proof, because if I don't get the proof, then you don't get the 5 days, okay? Or you don't get the 28 days. So
Okay.
the number to apply for the assistance is 248-269-1335. So read that back to me.
248-269-1335.
Yes, and then you've got to email that proof. You can just screenshot it and put your case number on it, this case number. Email that back to me at civil@45dc.org. Civil is spelled.
Wait 1 second. I'm going to get another pen. I'm sorry.
Door right past the wall.
All right, we're off the record for just a moment while Miss Union
Send it
finds a
into
pen.
us to
Do we
email?
hold on, Miss Union, we're off the record in your case. Do we need to get the jailer with the attorney?
Oh, he's back.
As soon as she gets here.
She's not here yet. Okay, fine. All right, then I'm recalling 2403349 LT. All right, Miss Union, you ready to take down that email?
Yes.
So it's going to be C as in cat, I as in igloo, V as in vase, I as in igloo, L as in law, at 45, D as in district, C as in court, .org. So civil@45dc.org, and make sure that you put your case number on that proof that you've applied. And that will get you a little more time. We're going to send a hearing date out for you. If you are trying to structure a payment plan with your landlord, don't wait to do that, because if it's paid off before the next court date, what happens, Mr. Morton?
He needs to make sure she's present in court to make sure that the case is dismissed.
Correct. If we send out a new date, correct. Okay. All right. So we're going to schedule a hearing date for you. That's going to come to you in the mail. All right, Miss Union, good luck.
No, I was listening. So apply for financial assistance at 248-269-1335. And once I do that, send a proof into civil@45dc.org.
Correct.
And then if I pay before the next court date, you say?
So if you're trying to work something out with your landlord, make sure that you're doing that now. Don't wait to do it. But if we send you a new hearing date in the mail, make sure, even if you think you paid it off, just make sure that you come back for your next court date if you get a notice in the mail. Okay.
Okay. Because I have been working something out with them, but they did tell me just as protocol, I would have to go through this.
Miss Union, if they're sending their lawyer to court, you have not worked something out with them. So, okay.
Okay.
All right. Make sure you come back on the next date we send you.
Okay. Thank you.
Good luck. All right.
We have not seen Browning, Montez, and Morris.
All right, we'll call some of these defaults, Mr. Morton, as soon as my file lets me do that. All right, let's see. Start with Morris. All right, this is 2403348 LT. This is Huntington Park Townhomes versus Morris. We have not seen Mr. Morris today. Go ahead, Mr. Morton.
You're at this time would ask a default judgment for possession to be entered. Rents retained $3,033.57. Court costs of $178.43 for total of $3,212.00. This is a non-payment of rent for possession only. And the statutory writ time period, according to our records, would be the 24th.
All right, default judgment will issue for possession only. Rent retained for the amount placed on the record. You can get the writ January 4th. Noting defendant has failed to appear. All right.
Sorry, what was the writ date?
The 24th. you go. All right, this is 2403733LT. This is the Oaks on Lincoln versus Bridges. We have not seen Bridges. Hold on. We already did Bridges. All right, off the record. This one just didn't get sent over. But it's about to. All right. All right, this is 2403337 Huntington Park Townhomes versus Browning. We have not seen Browning today. All right, go ahead, Mr. Morton.
At this time, we'd ask a default judgment for possession to be entered, rents retained, $7,137.12, court costs of $178.43, for a total of $7,315.55, non-payment of rent, possession only.
All right, default judgment will issue for possession only, rent retained for the amounts placed on the record. You can get the writ on January 24th.
Sorry, can I have the arraignment file back?
Yeah, that's fine. I'll just get one more default to do. Are you ready or do you want me to wait?
I'm ready.
Okay. All right, this is 2403347 Huntington Park Townhomes versus Montez. We've not seen Montez today. All right, go ahead, Mr. Morton.
Your Honor, based on the defendant's failure to appear, we would ask a default judgment for possession to be entered, rents retained, $1,594.02, court costs of $178.43, for a total of $1,772.45, non-payment of rent for possession only.
All right, default judgment, possession only, rent retained for the amounts placed on the record, and you can get your writ January 24th. All right, I think that concludes our docket, Mr. Martin.
Thank you very much, Your Honor. Good luck the rest of your day.
Okay, you too. This needs to go over.
I believe so.
hear it. Even if you give it
Okay, this is 250003200. This is the People versus Demetrius Smith. We're here for an arraignment. Go ahead, Ms. Costello.
Good afternoon. On behalf of Mr. Smith, who's present, we're here as the court stated for arraignment on this one count of domestic violence. He's been advised of the charge as well as his rights. We would waive formal reading, stand mute, ask the court enter a not guilty plea on his behalf. He's indicated to me that he will have retained counsel for this.
All right, we'll enter a plea of not guilty on his behalf. I'm going to indicate that at this point he needs court-appointed counsel. Sir, you are welcome to retain an attorney at any time. But if you do not, we will have counsel appointed for you. Just know that you have to have counsel by the next date. We don't adjourn cases forever to allow someone time to seek an attorney that they want. You've got to have your attorney ready to go. Otherwise, we're going to appoint one for you. Our pretrial is going to be February 5th at 2:40. That's February 5th at 2:40 p.m. Ms. Costello, let's talk about bond.
Yes, Judge, was there a pretrial service report prepared at all?
There was not.
Okay, so I'm not familiar, obviously with any sort of history. Mr. Smith indicated he doesn't have any criminal history. He is self-employed. He has multiple businesses. He does have a minor child that he was supposed to be picking up today, unfortunately, from school. He's indicated to me, obviously, that he's going to retain counsel, so he's going to be prepared with that, hopefully at the next court date. All that being said, and I don't know from the ticket who the alleged victim is, but we discussed the fact that the court would be entering a no contact order. He will abide by that in whatever terms the court sets. So respectfully, we're asking that the court grant him a personal bond for his release today.
All right, do you have a good phone number and good address for him?
Yes, I have a phone number is 586-525-9535. And then the address that is on the ticket can be used for mailing purposes. I don't know if I don't know where the allegation occurred at actually. So
let's say it occurred at a store. Give me just one moment.
The allegation occurred at my store.
At your store?
Yes. Correct. I don't know what the name of it is though.
Okay. He can receive mail at the address on the ticket.
We're still going to need his address, his home address.
So he's going to be staying at a hotel. He's going to make arrangements. So he's not going to, he doesn't know at this stage. Is that correct? Is that fair to say, Mr. Smith?
Yes.
Okay.
All right, so the address that I have is the 23140 Coolidge Highway.
Oh,
that's a good address. We received it.
All right, what business is there?
Retail.
Give me the name, sir.
It's called Beauty House Bundles, BHB Holdings, if you look it up.
You don't know the name of your business?
I said it's called Beauty House Bundles, but if you look at it's Beauty House Bundles.
Ms. Costello, do the complaining witness and the defendant reside together?
No, he indicated he's not living together.
So where's he been living? If he's saying he's going to a hotel, that told me he hasn't been.
I'm not sure, Judge.
Mr. Smith, I'm going to need a little more information here. Where have you been living?
So we was living together, and I moved out last night. So I moved out while she was gone. But I have multiple properties to live in. I don't have to go to her.
Okay, you just said you're going to a hotel. You're going to one of your multiple properties. What is the plan here? Okay, make sure that
for the rest of the week, I'll be in a hotel.
Okay, please make sure that you provide that information to the court.
Okay.
All right, looks like the defendant has prior for animal fighting. The allegations involve punches to the face, to the stomach, throwing of a glass table. Officers observed blood on the complaining witness, on her face, cuts to her hand. Given the alternative proofs in this case, the likelihood of conviction is high. Defendant has prior history involving violence involving animals, which is of concern to the court also. It seems like domestic violence and animal cruelty seem to go hand in hand. All right, I'm going to set his bond. I'm worried that he is a danger to the community. I'm going to set his bond at $25,000 cash or surety. He's to have no contact with Hamada Triplet, no contact with 23874 Northstone Village Drive. No firearms, no dangerous weapons. Sir, if you do make that bond, you're going to have to turn in that firearm that was used in this offense to the police.
Can I say anything?
Sir, I would advise not to make any statements about what happened, okay, please?
Okay.
He's going to have to be supervised by pretrial services. There'll have to be weekly check-ins. Defendant must provide a valid, stable address upon release. We will see him back on February 5th at 2:40.
Judge, just on his behalf, the court won't consider a 10% on that bond?
I will not.
Okay, thank you.
Everyone have a great day.
Thank you.
Thanks, Ms. Costello.
Thank you, Neil.